Burmeister, approaching. State your name, please, sir. Kyle Brian Burmeister. Your Honor, we are requesting an adjournment to possibly resolve this case along with his other pending misdemeanor case Ms. Bondi has. So I'd be asking for a 2-week adjournment, and then I can address the bond issue.
You need to address the bond issue before I'm going to give you an adjournment.
Your Honor, my client tells me he never had noticed that he had to go to community corrections on this case. And I am looking at the court activity from this file, from the arraignment that he was given. It only indicates bond amount 5,000, personal recognizance. There's nothing listed in the conditions section. I went through all this paperwork and said he's kept everything.
Except he was advised on the record that he would be subject to drug testing on that same day by Magistrate Odetella, and I have that form. So I'll match my form against yours anytime.
Well, all I can add, Your Honor, is that he actually had...
Why didn't he go?
Inpatient treatment.
Did he go over?
He tells me he didn't either recall or didn't have anything to explain, I think, once he was released from jail. In any paperwork that said I had to go. And so maybe with the confusion of these cases, the good thing though, Your Honor, is I have verification. He went to the JIRA residential from February 25th, and he completed that actually early on March 7th. He can test today. He's telling me he should be fine. He is not in...
I'll pass it. He needs to get over there and test now.
Thank you.
All right, folks, buckle up. This case has everything. Confusion over court orders, rehab, drugs, and even allegations of cocaine trafficking. Let's see how it all unravels, and I'll break down the key moments along the way.
Tell the case of the people versus Kyle Burmeister.
James Gladfelski on behalf of Mr. Burmeister, who is approaching. We are in receipt of the community corrections report. I can advise the court that it is my understanding, and I believe he actually has the pill bottles to verify, he has prescriptions for the benzodiazepine and buprenorphine. My client does not have prescription for alcohol.
He certainly does not, and that's prohibited, Mr. Allen.
Your Honor, if I could just make one...
Go ahead, make your argument. I'll let you say what you're going to say.
Records I have obtained so far have shown me that leading up to and prior for probably several years, Mr. Burmeister has been a patient at Washtenaw Community Mental Health. He also sees addiction specialists over at IHA at St. Joe's Hospital, which is his aftercare, which he is continuing after he completed the residential Oakdale Recovery Center, which I have proof right here. So we have a situation, Judge, where somebody who is struggling with addiction, doing as much as he can to address that, to be clean and sober, and getting help from several medical professionals. My request, Your Honor, is that the court consider the ankle alcohol tether to monitor him 24/7. I know he wants to be sober. He's just struggling. And as far as addiction, the court is well aware that it's not an easy process. So I would ask that you keep him on bond with condition that he get on the tether.
He didn't go to community corrections. We sent him over to community corrections. He comes back positive.
I understand, Your Honor. For at least several of those weeks, he was in program. And I have proof to verify that. So getting help, detoxing, getting inpatient rehab care.
Set this for April 3rd, 2025, 9 a.m. I don't need a response from the people defendants.
I believe that the facts set up everything that's needed for count one, as it clearly shows that it's a substance controlled substance, is cocaine. It was tested by the True Narc. In this case, Officer Hussein testified about finding the narcotic residue inside the vehicle. Then the two larger bags, which were found at the hospital. In this matter, the defendant was the only one in the bathroom at the time in which these narcotics, or prior to.
Notice what just happened here. The judge basically called out the defense on conflicting paperwork. Quick question for you. Do you think it's the lawyer's job to double-check every single condition, or should the burden fall on the defendant? Let me know in the comments.
These narcotics being discovered, he was informed not to flush the toilet, did so anyway, was also informed not to basically make sure that he could be visualized. In this case, he saw that he bladed himself towards the trash can away from the view. There was fervent movements with his hands, and then all of a sudden there happened to be, while he washed his hands, there's two baggies of one bag of cocaine, one bag of crack. It just happened to be wet at the time in which, generally right after he washes his hands. Your Honor, so it's been tested and shown as far as count one is concerned. But when it comes to count two, Your Honor, I believe Officer Hussein's testimony is very relevant into the indications of narcotic trafficking in cells. It's our position, Your Honor, based on the fact that there was a scale there, multiple small baggies for numerous small baggies for packaging, tear-offs, which are commonly used as packaging, two different types of narcotics placed in two different bags, both of which are above the normal use for personal use. In this matter, we have one at 14, I believe one at 30 grams, Your Honor. One of those, I believe, which would be the cocaine, this pure cocaine, Your Honor, 30 grams, that's over an ounce. He had over an ounce of cocaine and then approximately half an ounce of crack cocaine, Your Honor, with baggies, with the scale. Those are every single thing beyond our address book that one would need for distribution, Your Honor. So we do believe that there is more than enough probable cause to sustain the additional charge that the people had requested, which was a possession with the intent to deliver, which would be
Here's the tug of war. The defense paints Kyle as a man fighting his demons with doctors, programs, and rehab. But the court is weighing whether he's genuinely trying or just buying time. Classic courtroom tension.
Delivery of manufactured controlled substance less than 50 grams. We showed that the total weight of this was 45 grams, Your Honor, just under that 50-gram threshold, and that it was all cocaine or a mixture that contains cocaine, Your Honor. So for those reasons, and of course, we've already established venue, time, location, and identity. So, Your Honor, at this point, we do ask that the court bind over on the original count one and the added count two of delivery and manufacturing of a controlled substance less than 50 grams.
Thank you. The first element of this, of course, is that defendant possessed controlled substance. In this case, the allegation is cocaine and crack cocaine. There was a pat down and a full search before the hospital, before any of these allegations happened, by trained law enforcement officers. They know how to do the searches. Well, Officer Colorasi was in training, but also trained to do a search, obviously. Nothing was found on my client's person. Nothing in his system from the blood draw. No drugs, no alcohol. So really the possession comes down to these two bags that were found in the trash can in the hospital bathroom. A bathroom that is open to the public 24/7, doesn't require any special entry. Anyone could walk into that hospital and use that bathroom. I was curious how often they cleared the trash can, but the officer from the hospital didn't know. So obviously those bags could have been there for any amount of time. The officer from the hospital testified that my client had irregular hand movements, but at the end of the day, all he said was, well, he was drying his hands for an irregular amount of time or something to that effect. I mean, that's...
This is a huge moment. The prosecutor just shifted gears from possession to intent to deliver. That's a far heavier charge. Why? Because scales, baggies, and 30 grams of cocaine scream dealer, not user. The stakes just skyrocketed.
I just, I just don't think there's a lot there to support probable cause, respectfully. And no one saw my client put anything in the trash can. And of course, Your Honor knows there's two types of possession, right? Actual and constructive. Presumably the people are arguing both, that he actually possessed these, but, that nothing was found on his person. Constructive possession is, of course, and then there's case law, I think Mr. Danner is aware of. There's a Sixth Circuit case interpreting Michigan law, and then there's a Michigan Supreme Court case, and I have the citations, I'll mention them quickly, but basically proximity to contraband is not sufficient proof for possession, for constructive possession. There has to be something else connecting a defendant to the contraband, whether it's a weapon or a controlled substance. And I won't go through a lot, but I would just like to, for the record, say that I'm referring to a Sixth Circuit case, Parker v. Renico, 506 F3rd 444, interpreting Michigan law, decided October 17, 2007. And that case cites many cases, including a Michigan Supreme Court case, People v. Wolf, WLFE 440 Mich 508, decided in August 31st, 1992. Very briefly, what the Sixth Circuit says is, as with the federal rule, a person has constructive possession if there's proximity to the contraband, together with indicia of control. In other words, proximity alone never suffices. Cites a Michigan Supreme Court case. And the ultimate question, according to the Michigan Supreme Court, is...
And there it is. The judge rules there's enough evidence to take this to trial. What do you think? Is the system being fair, or is Kyle getting crushed by circumstances? Drop your verdict below. I'll be watching the comments.
Whether the evidence establishes a sufficient connection between the defendant and the contraband to support the inference that the defendant exercised dominion and control over the substance. That's beyond the mere proximity. So I respectfully assert that there is not probable cause on that first element for actual or constructive possession. The second element, defendant knew that he possessed a controlled substance. That would have to be inferred. There's no evidence of that. There's no statements or admissions. So that would have to be inferred from the first element. And, well, there is testimony of the weight. So that's the third element. So for all those reasons, well, I'll leave it at that. Thank you.
I really don't need rebuttal. The court would find that the people have sustained their burden of showing sufficient evidence that there's probable cause to believe that the defendant committed the offense of possession of a narcotic less than 25 grams. Also, given all of the testimony, in particular that by Officer Hussein, there is enough. This court believes that the defendant should also be bound to stand trial on the additional charge of possession with intent to deliver a controlled substance less than 50 grams. And so the court would bind the defendant over to circuit court on both those counts. The court would also indicate that the issues that are raised by the defendant with regards to those cases and actual possession, the court does find, for the purposes of probable cause, that those particular prongs under either test are met, to the extent there might be an argument as to what could be inferred or the intent that this court would believe would become a question of fact that would properly be before the jury. But I think there's enough there to bind the defendant. Well, I know there's enough there to bind the defendant over. Defendant's bound over on counsel.